Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. So you've got a Virginia car accident case and you're wondering, James, should I file in the circuit court or should I file my case in the general district court? Whether or not you decide which court to file in is really going to depend, I think, on a few important issues. Number one is how much do you want to sue for? Number two is how quickly do you want to get into court and get into trial? And number three, among other things, what litigation costs do you want to occur? Do you want to have to bring in doctors versus being able to use medical records and the effectiveness? And also, the other aspect is what happens if I win or lose, and the possibility of appeal in the general district court versus the circuit. So when we're talking about the first issue, the value of your claim, be aware that under Virginia law, as it stands here today, in order to file in general district court, the most that you can sue for is $50,000. Now, this is actually a vast improvement from a couple years ago where the jurisdictional limit was only $25,000. So it was essentially double the limit there. And for complex injury cases, but pretty good recoveries, $50,000 may or may not be enough for your claim. So if you've got a case that you believe the highest you would ever get is $50,000, or sometimes in situations where it may be a little bit over $50,000, it may make sense to file in the general district court depending on your case. Now, of course, this is going to be an issue when it comes to assessing value. That's a much more complicated issue. What type of injuries did you have? What are your medical bills? What's your recovery? Do you have lost wages? That question is going to be a separate one. It's a subject of different videos that we've done. And I would urge you to go to our website and our YouTube channel to check that out. Now, the second question is how quickly do you really want to get to court? When you file in the general district court, you're typically going to get a much quicker trial date. Typically, I would say anywhere from 3 months to 5 months to 6 months, a little bit longer. If you're filing in any Virginia circuit court, you're typically not going to get a trial date for at least 9 months. As it stands here today, we're still coming out of COVID. You're probably looking at a year and a half, in some jurisdictions over 2 years. So the benefit of going to the general district court is you're going to get a quicker process. Now, the downside and the reason that it's quicker to get in the general district court is you don't get the type of discovery that you would get in a circuit court. What do I mean by discovery? Discovery is certain things like being able to ask the other side written questions called interrogatories, being able to produce document requests where you're requiring them produce documents to you, being able to depose them where you actually have them sit down in front of a court stenographer, sometimes on Zoom as we're now in the COVID world, and where you can actually ask the defendant questions prior to trial so you can have a better sense of what they're going to ask. Now, that being said, another benefit that may be in your favor when it comes to a lack of discovery is in the same, on the other side of the coin, they also are not going to be able to get the same kind of discovery they would be able to get in circuit court if you file in general district court. So for relatively simple factual cases, let's say a rear-end car accident case where you don't really care a whole lot about what the defendant would say because you know he rear-ended you or she rear-ended you, discovery may very well not be that important. And also it may benefit you by them not being able to depose you, sending you medical rec requests and things like that, and requests for production of documents that may benefit you. Now, I will say for more complicated cases, for instance, slip and fall cases where you need to figure out exactly what witnesses saw what, complicated factual cases where there's multiple parties involved. Maybe you don't know who the party is. Let's say you're suing a company or there's multiple potential defendants where you're going to want that discovery. General district court may very well not be where you want to go, even if you have relatively simple injuries. But that's just something to be aware of. You're going to get to court quicker, but there are going to be avenues that you're not afforded that you would be in the circuit court. Now, the other aspect is whether or not you have to bring in expert witnesses. Your doctors, your treating doctors, other experts that may be involved in your case that help you establish either fault or some other aspects, let's say a products liability case where you're having experts talk about the mechanics of the actual thing that hurts you, or a premises liability where you have an expert talking about the area that you fell on. If you file in general district court, particularly when it comes to your medical doctors, there's avenues by law that allow you to bring in, so long as you have certain affidavits in line, to bring in medical records to establish your injuries. Sometimes to actually have doctors write reports, so long as they do certain things that you can actually present to a judge. Why does that benefit you? It usually is very difficult to get your treating doctors to come in and help out. It's also very expensive. So that's another benefit of being in general district court. It streamlines the process and it makes it cheaper to get to trial. So if you're in general district court, it's cheaper and quicker. Now, the downside of that may be that you might want your expert witness there because they are needed really to establish your injuries. Let's say you have a complicated brain injury, or let's say you have an injury that the defendant is claiming that it's due to some other cause, that you think that an expert witness or your attorney thinks an expert witness is going to be necessary to establish that cause or to help a judge understand, or a jury, but in a general district court, a judge understand the mechanics of your injuries. You may want an expert there. It may make it worth spending that money. Again, that'll also couple with the value of your claim. So if you're involved in a much more serious accident and you have a much more valuable claim, that's again why you would want to file in the circuit court. So the other thing is, when it comes to general district court appeals that you want to consider, is what happens if you win or lose. When you file in general district court and you lose, there's an automatic right to appeal up to the circuit court, to where you can get a jury to hear your case. And that's another thing, is a general district court, it's just going to be in front of a judge. It's not going to be in front of a jury. You only get to the jury when you get to the circuit court. But if you lose in the general district court, you can get an automatic right to appeal to the circuit court, and also get the benefit of having a jury if you want one. You can also use those rules of evidence that allow you to get in reports and medical records from the general district court up in the circuit court. But if you're in front of a jury, you may want to consider whether or not that makes sense. Now, that being said, a downside of the general district court is if you win, the defendant has an automatic right to appeal as well. So if you get a good result in the general district court, you may be facing an appeal, because it's a simpler process than appealing from the circuit court. When you appeal from the general district court, it's de novo, meaning it's a brand new trial, and it goes up to the circuit court for another trial. If you're appealing from the circuit court is what we call a court of record. So appealing from a circuit court, you can only really challenge legal issues. It's not like the Court of Appeals is going to hear brand new evidence. It's stuck on the record, and whatever was presented at the trial is the only avenue to appeal up to the circuit court. So many times, in many instances, it's just more difficult to appeal up to this to Court of Appeals from the circuit court than it is from the general district court up to the circuit court. Now, another change, in addition to increasing the jurisdictional limit from 25,000 to 50,000 that the legislature recently did, was also require, in order for the defendant to appeal, if you get a judgment against them and they want to appeal that case, they've now got to post that money. They've got to post that bond in order to perfect their appeal. So that means they got to put up money or shut up. Now, obviously, if they win, they only have to pay what's required, or they don't have to pay it all, and they'll get that money back. But in order to establish that appeal, they've got to actually put the money up to demonstrate they've got it. And sometimes that may very well be an incentive not to appeal, a disincentive to appeal. So it makes more sense to go in and not to appeal for a defendant. Now, whether or not your case ultimately should be filed in the general district court versus the circuit court, again, I think this is a very intimate question for you and your attorney. I always tell people, look, there are certain situations where you can represent yourself. You may not need an attorney. If you're having to go to court, I always recommend that you hire an attorney. I think the trial aspect of any case is complex enough. The rules of evidence are complex enough that you don't want to be learning on the fly. You don't want to be learning from your own case, because that means bad things. That means you may lose, or you may have a substantial part of your case kicked out and you're in trouble. And that's not good. So I think it's worth hiring an attorney if you're ending up having to file your case. The question that you and your attorney should be asking is, does it make sense to file in the circuit court versus the general district court? And again, if you're trying to get a quick case, a less expensive case, that's where the general district court case makes sense. If you've got a complex injury, though, if you've got surgery, you've got fractures, and assuming there's enough insurance coverage, the circuit court is likely going to be where you want to go, even if you've got to go through discovery, even if you've got to have expert witnesses. The reality, though, is If you've got a case that's worth over $50,000, let's say you think the case is worth $300,000 or $500,000, you're going to be asking a jury to award you that amount of money. Even if you have to pay for your expert witnesses or your attorneys paying for that up front, you're going to have to reimburse. I think it absolutely makes sense to hire the doctor to come in, hopefully your treating doctor to come in to explain that injury. I can just tell you that juries, I think, respond better or would respond better to a doctor, somebody that's trained in the medical profession that can brag about their credentials, that can talk about how they laid hands on you and evaluated you and diagnosed you with X, Y, and Z, and they can post pictures and anatomic photographs and anatomic diagrams to help explain your injuries. I think it's more interesting for a jury. I can't imagine being in a situation where I would want to hand the jury a bunch of medical records. I think that would be a risk. And I can tell you, if you're in the circuit court, most likely you can expect the defense to hire a doctor. And so even if you could somehow try your case without an expert witness, I think it's going to be hard evidentiary wise to do that. But even if you could, you got to expect the defense is going to hire a doctor. So you're also going to want to be able to go head to head with their expert witness and be able to argue and have your attorney be able to argue to a jury why your expert is right and their expert is wrong. So this video is obviously an oversimplification of that important decision about whether or not to file in the General District Court versus the Circuit Court, but it's certainly an important one. I think that the purpose of this video is to kind of provide you flags on what you should be thinking about and talking with your attorney about. If we represent you, it's certainly going to be a discussion that we have intimately with you, because once you file, that triggers different things. Now, there is an opportunity, if after you file, to either move the case from Circuit Court down to General District Court or General District up to Circuit Court. But I don't really like doing that. I think the more complexity you add to a case because you haven't thought it through, does it does that. It adds complexity, it adds more stress to you, uncertainty. I'd rather go in strong, make you be aware, if I'm representing you, exactly what you should expect or the best that you can expect as possible, and then let's get it done. So hopefully this helps you understand the process a little bit better. If you have any other questions, you can reach out to us, www.abreniolaw.com. You can give us a call, phone number 703-570-4180. Thanks a lot. I wish you the best. Take care.